Yes.
Chief Inspector Dixon Tinyo, of the Serious Crime Unit of the DCI. The affidavit in support is dated on a legal date. He tells this court, Your Honor, that he is in the course of investigations for, among other offenses, the commission of terrorist acts, unauthorized access to computer systems under the Cybercrime Act, unauthorized interception and access with intent to commit further offense as per the same Computer Abuses and Cybercrime Act. Your Honor, it is important that the court notes that in 1970, there were such occurrences that led to the leaking of very sensitive, classified government information from the US, which was dubbed as the release of the Pentagon Papers. The intelligence servers were hacked or breached, and the history calls it the most famous, impactful leak of classified documents in the US history. The consequence or attendant risks that came thereafter made this title by various authors get converted into the title of the most infamous and impactful leak in the history of US intelligence. The reason I'm telling this court, and the court in this matter is in public domain, is that we cannot underestimate an action of actively breaching an ICT system held by the Ministry of Interior and National Administration, especially by participants of people contracted and trusted with such enormous responsibility. This court, myself, and the defense counsel knew note of the existence of these domains. What the Ministry of Interior is telling you, Your Honor, is that what has been breached is very a system full of very sensitive data. And this data in the hands of the intended recipients that are yet to be unearthed is dangerous data and could cause havoc, as was caused in the scandal of the Pentagon Papers leaks. We are asking this court to consider that with the attention that it deserves. Article 27 of the Constitution talks about privacy. And for you to breach the privacy of any individual, you are warranted to come to a court of law to allow the same breach of privacy for a lawful reason. There is need to understand the reason why the first to the sixth respondents have been mentioned in this application adversely, and there is need to understand their level of participation, and there is also need to understand the reason and the motive why the said breaches were happening. You've been told that they've been positively identified, Your Honor, as the handlers of the system. A system, an ICT system cannot breach itself. There must be a human intervention for the same breach to happen. Is it therefore wrong for the state to understand the reason why such sensitive data is being breached? How complex are these investigations? How complex is it to breach a data system held with the Ministry of Interior? You will require very serious skills. You also require very serious audacity. And you must have known that you are doing something very, very serious. A breach of personal email could cause embarrassment. But a breach of a critical national security infrastructure could end a country. Your Honor, this is not a simple one. On what basis are these people held? Your Honor, on the face of the application, under Article 49(1)(f), the respondents have been presented before you within the 24 hours rule. Under Section 33 of Porter, the investigators, Your Honor, and I read the wordings of Section 33 of Porter, an act that was passed for a specific purpose, to prevent, and this, Your Honor, is the title, short title I'm looking for Porter. It's an act to provide measures for the detection prevention of terrorist activities. This act is not about prevention only. It's even about detection. Was it just hacking? Let's go to section 2 on the definition of a terrorist act. You know the same definition at paragraph 7 indicate that a terrorist act means an act or threat of action that interferes with an electronic system, that is 7, resulting in the disruption or provision of communication. Interferes with an electronic system, resulting in disruption of the provision of communication. Financials,
and we just mentioned for the sake of it, resulting in the disruption of
provision of communication, financial, transport, or other essential services. The Minister of Interior will not receive their communication, disruption of communication. Was that domain ICT system an essential service? Indeed it was. At paragraph number 8, the Act continues to say that a terrorist act also here means an act or threat of action that interferes or disrupts the provision of essential or emergency services.
Terrorism Act also means a threat. Sorry.
A threat or an act or a threat of action that interferes or disrupts the provision of essential services or emergency services. You know, the Minister of Interior keeps everyone alive in Kenya. That is the security. That is a very essential service to the country. You know, at paragraph number 9, a terrorist act also means an act or threat of action that prejudices national security or public safety. That breach prejudiced the national security. That breach prejudiced the very public safety. It's not an ordinary crime. Yona, at paragraph B, this act is carried out with the name, the motive. The IO was before you here, and he's telling you that we are now going to the motive. We have already established a terrorist act, but what was the motive? Allow the IO do the due diligence and uncover the motive behind the hacking or the breach. Can you remind my time?
56 minutes.
14.
14.
Just to sum up. Jonah, if the matter will be concluded and the respondents will be charged, Your Honor, Section 4 provides on the seriousness of the nature of the first offense. And I will not deal with the cyber issues. The court will take notice of the provisions highlighted here due to the high impact. It is stated that a person who carries out a terrorist act commits an offense and is liable on conviction to imprisonment for a term not exceeding 30 years. By not exceeding, the act gives the full discretion, depending with the manner and the damage the terrorist act has caused the nation or any section or segment of the nation. And it could exceed, it could go up to 30 years. Very serious issues. So we are telling this court to just balance. An investigation is like drawing a person. And if the person, artist, is interrupted, you will not be able to tell whether he was drawing a car or a person. We need to give the artist here, the fact finder in this case, sufficient time to draw that person to completion. If the investigations are completed before, then we will, in good faith, come to this court and request that they be discharged. If they are completed and any of them is culpable, then we will charge even before the expiry of 30 years. Yona, section 33. And this is the last thing that I submitted to Mr. Mwai. And this is the reading. A police officer who detains a suspect may, where he has reasonable grounds to believe that the detention of a suspect beyond the period specified is necessary, produce the suspect before court, apply in writing the court for extension of time for holding the suspect. The threshold is not as compelling as in other laws, Your Honor, and this is of submission. Section 3 has a purpose that even a police officer with reasonable grounds to believe that detention of a suspect beyond the period specified is necessary. Reasonable grounds to believe. The Constitution says the state has to give compelling reasons. The Constitution states that these rights are not limited except by law. Except by law. And then the Constitution has given us a law called order. At section 33, the IO has told you that we have reasonable grounds to believe that extension to a period of 30 days is necessary. And we ask the court to find as much. Yona, you go through the Act 1 and 2, that is section 33, 1 and 2. We've already complied with what is required of us. We've given the notice, the application is served upon them, and we've given the extent of the investigation and what remains, Your Honor. And you're being told the hacking has happened, the breach. Now the motive is what the IO is looking for. You will be told about orders that were granted in respect to searches. But Your Honor, when they start submitting of such aspect, and this is my submission, whether the said search was conducted pursuant to a court order. Can anybody direct the National Police Service not to investigate unless the court sees excesses? Your Honor, I would wish that once you retire, you go to Article 243, 244, and 245 of the Constitution. You will find that the IOs, in this case the National Police Service, cannot be directed as to the manner of investigations. You'll be told that they should have come here to do a search warrant. They tell you these people should be released. Let them be investigated from home. The Constitution, which is the supreme law of the land, states that no one can direct a national police service through the IG's command on how to do the investigation. Please, for the sake of this country, allow the IO to do these two investigations. And I've seen an extremely generous IO who comes for 30 days, Your Honor, and the Portal, Section 33(10) requires, Your Honor, that this period could go up to 360 days. Constitutional limitation of holding a suspect on terrorism for 360 days. And they are asking you, 30 out of 360, Your Honor, is quite reasonable. So we kindly request, Your Honor, that you have this application. And we reiterate, Your Honor, that paragraph 18 has not been controverted. They are asking the IO, what if we give the home residences of these people? And the IO is telling you, as at the time of arrest, their places of abode were unknown. The IO is telling you that the nature of investigations, and he's the bearer and the custodian of facts in this case. The IO is telling you the data that they are investigating and the nature of evidence is very volatile at any time they are putting it. We need to have these respondents in a controlled environment.
As provided on compelling reasons to have the respondents on stay in custody for a period of 30 days. To enable the investigators to move the investigations, Your Honor. Your Honor, I will base on my submission on the thematic area under Article 49, 1H, Your Honor, of the Constitution. With regard, Your Honor, to the gravity of the offense, which is being investigated, Your Honor. Your Honor, the alleged deliberate and unauthorized access targeted, Your Honor, sensitive government systems. And Your Honor, the aim was to disrupt operations or leak, Your Honor, classified information. Your Honor, it is clear that the said breach, Your Honor, meets the threshold for cyber terrorism as provided for under Portal, Your Honor. Because, Your Honor, the intent was to undermine national security in its operations, Your Honor. Your Honor, I wish, Your Honor, to refer the court to an authority Director of Public Prosecutions versus Bajbar and the two others, Your Honor. Bajbar, B-A-J-B-E-R, and two others.
5 minutes, Your Honor.
Whereby, Your Honor,
The authority again.
Your Honor, Director of Public Prosecutions versus Bajbar and two others, Your Honor.
Yes.
Criminal Revision E168 of 2023, Your Honor.
E168.
E168. Yes, Your Honor. 68 of 2023. Yes, Your Honor. Whereby, Your Honor, Dr. Kabeza Judge in paragraph 18 Your Honor, cited the gravity of the offense as a consideration, whereby, Your Honor, she cited, Your Honor, the case that was adjudicated by Justice Mbogoli Msanga, Your Honor. Your Honor, the court will have a time order to peruse the said paragraph. Your Honor, she considered the gravity of the offense, Your Honor, to deny the respondents. Your Honor, what comes, Your Honor? Your Honor, as alluded by my colleague, the said breach, Your Honor, requires serious skills and audacity. And if, Your Honor, the respondents, Your Honor, released at this stage, they may delete, Your Honor, the sensitive information that is yet, Your Honor, to be availed to the investigators, because, Your Honor, they are highly skilled, Your Honor, in digital operations. Your Honor, also wish, Your Honor, to refer the court to another citation. Your Honor, High Court Criminal Case number 31 of 2020, Nairobi, Republic versus Kelvin Barasa Wanyama, alias James Kimani, Republic versus Kelvin Barasa Wanyama, alias James Kimani, where, Your Honor, Justice Muridi where Justice Lesit in paragraph 20 quoted the case of Republic versus William Mwangi, 2014 EKLR, whereby, Your Honor, she addressed what constitutes compelling reasons, Your Honor, to deny bail. Your Honor, in our application, the IO is yet, Your Honor, to establish a fixed abode of the respondents. And therefore, Your Honor, if released at this stage, Your Honor, there is likely, Your Honor, of them jumping bond. And also, Your Honor, they are yet, Your Honor, to be interviewed by a Martinez team. Which, Your Honor, is critical in this case, Your Honor.
That means, Your Honor,
and since, Your Honor, the evidence that is to be availed is so complex, which, Your Honor, will require cyber forensic analysis. Premature release, Your Honor, of the respondent, Your Honor, may obstruct investigative procedures that, Your Honor, will be entailed, Your Honor, to get, Your Honor, the proper evidence. Thank you, Your Honor.
Thank you.